mean, why does she get the benefit of the doubt? Because she's wearing a skirt.
Complaining witness then got one arm loose, grabbed the defendant's genitals, causing him to let go. And then the defendant then struck the complaining witness in the mouth, causing pain.
If you consent to, if you tell me to shoot you and I kill you, you don't think the cop gonna get me from her?
Those 18 seconds you just watched, that wasn't the whole explosion. It was the moment everything stopped making sense. A courtroom arguing about skirts, consent, and a single punch, but you haven't seen what actually led there. This is Mr. Sullivan versus the state of Texas. On the surface, it looks like a domestic assault case in Harris County, but underneath, it's a fight over who started it, who escalated it, and whether 10 minutes is enough time to reset guilt. He tells her to hit him. She does. 10 minutes later, she says he pins her down. So why is only one person charged? Why does consent suddenly disappear when the roles flip? And how does a cooling off period rewrite the law? If you want to understand how courtroom psychology and contradictions really work, subscribe for real cases like this. Let's go back to where it all began.
I'll just read you the PC summary again. So on March 23rd, 2025 in Harris County, Texas, officer was dispatched to a disturbance call and met with the complaining witness, stated that the defendant is her husband. The complaining witness stated that she told the defendant that she was going to move back to Arizona that day, and they got into an argument. The defendant then told the complaining witness to hit him in the face. The complaining witness then struck him in the face.
Right.
The complaining witness then stated 10 minutes later, she went into the bedroom where the defendant then laid down on top of her, grabbing her wrists, causing pain.
That's 10 minutes later.
That's 10 minutes later. Grabbing her wrist, causing pain. Complaining witness then got one arm loose, grabbed the defendant's genitals, causing him to let go. And then the defendant then struck the complaining witness in the mouth, causing pain. And the officer observed the complaining witness to have bruises on her arms and injuries to her top and bottom lip.
How is it?
I think we are omitting some things that's pertinent to the decision that you're gonna make.
What?
She asked, her daughter told her that you have to make a choice between.
Oh, that's right. Yeah. I remember. And then she makes a choice of him.
And she said, I'm leaving you and I'm going to be with my daughter and grandchild. And then he comes and tell her, if you're really that mad at me, then hit me. And that's when she went to him and hit him twice. Boom, boom.
How is it fair that I find probable cause on him and not on her? Why didn't they charge her?
So I would say one is the fact that he quite literally says to hit her or to hit him.
Can't consent to an offense, Judge. If he tells me to shoot me.
Yeah, no. I mean, you can, like, boxers consent to assault, right?
That's.
But I mean, in this,
I think where we are for PC purposes, as far as this offense goes, is that it occurs 10 minutes later. Then we have essentially in a situation where he can't essentially claim self-defense if he's the one being the aggressor first, where he's grabbing her 10 minutes after this kind of initial incident happened. He's grabbing her, then she grabs his genitals, and then he punches her in the face. I think that's where we're at as far as PC goes.
I don't think that's the law, Judge. I don't think you can avoid what had happened earlier just because it was 10 minutes later. I don't think you can take the fact away that she was the one that instigated and was the culprit of the initial assault.
but there's a long cooling down period. You know, if it's like maybe a minute or two after the fact.
I would say.
And then, but nevertheless, though, how's it fair that she's not charged? I mean, why does she get the benefit of the doubt? Because she's wearing a skirt.
I mean, the code does say you can consent to an assault.
If you consent to, if you tell me to shoot you and I kill you, you don't think the cop gonna get me from her?
Well, you can't consent if there's serious bodily injury involved. You can't consent if there's no threat or actual serious
Come up,
bodily
Mr. Sullivan.
less than the serious.
I mean, an assault does occur in this case with him and her, but there's also another one that occurs, you know, so.
I would argue, Doug, that at this point, with the charge that we have, that's going to be fact issues that I'm sure we're going to parse through moving forward. But I think that's.
And I think it'll work to the benefit, you know. So, Mr. Sullivan, I'm going to find that there's sufficient probable cause to go forward with your case. Don't have any contact with this person, please. The only thing I'm going to ask you to do is don't pick up any new cases, don't have contact, and don't be possessing weapons. I don't know why they didn't charge the other person. I don't understand. And I don't know. But be it as it may, just don't have contact with this person. I think that, you know, it's just, could be like a rumbling volcano. And the last thing we want to do is we don't want anything more to erupt. We don't want further charges and just, and I think that, they'll take it into account when you guys are talking about this case, but just stay away. That's all I'm asking you to do. Okay.
But Judge, with all due respect, I don't think it's too late to not to file charges against that person. I mean, I've seen cases where they're filed charges.
That's not me. That's up to the DA's office and intake whether they.
Then I think the DA's office should take that in advisement to file charges against the person who was the actual initiator of the contact between these parties. If they do it all the time, I've seen cases where the district attorney filed cases 1 year later, when they know that there's evidence to substantiate the filing of a charge against somebody.
Who knows? Maybe it will. I don't know. Do you mind filing no contact, no weapons? I've given you a lawyer. All you'd have to do is just stay in contact with Mr. Dixon. He'll tell you if and when you have to come back to court. I'm going to waive your appearance so you don't have to waste your time coming to court. Just stay in contact with him and he'll tell you if and when you have to come back. Don't leave until you sign the bond conditions. Once you sign them, you're free to go.
When I get put some money.
Go. Take your time. But just come back.
Okay, I will. Thank you, sir. Thank you.
Take care, sir.
So the decision came down. The judge found probable cause, and Mr. Sullivan walked out under strict conditions. But here's the real question. Was that the fairest call? If one person starts it, another escalates it, and time sits in between, who should actually face charges? Comment below. Team Sullivan or Team State of Texas? And if this case made you think twice, hit like and share it with someone who follows real courtroom drama.